start because we have limited time to everyone has
Yeah.
schedules. Is it visible?
Yeah. It's visible.
Yes, ma'am.
Okay. Hi Abhishek, you there?
Yes, ma'am, I'm here. Am I audible?
Let's begin. Okay. So, first of all, I wanted to ask: have the applicants or candidates bought the Patents Act? Abhishek must be having already, I believe.
Yes, ma'am. I have the older version. I have to still get the new one.
No problem, but at least you are yes, because you've already done law, so you are in touch with it.
Yes, ma'am.
Problem. Why is it not changing? Why is the slide not changing? Just give me 1 second. I will share it separately. Now is it visible?
Yes, ma'am. The first slide is visible. Actually. The first slide only we are at.
Okay, okay. Is the second slide visible? Because from there I was not able to change. I don't know.
Yes, ma'am. The first slide,
Okay,
second slide is now visible.
okay, fine, fine. Then I'll just. So, hello everybody. Today is our second class for the patent agent course, and I hope you've already applied for the form. Please do it as early as possible. So, in today's session, we will cover a little brief history, how the patent law has evolved from the year 1856 to the today's time, and how is it structured, like what exactly is the Patents Act, how are the rules, what are the forms and everything briefly, and what is like behind this whole system, who runs this whole system. Last time also we had an overview about the ministry and then the patent office and what are the four patent offices. Now, uh, after that we will go through like what we'll have an overview about what type of different patent applications we can actually file and complete patent life cycle from grant to beyond, filing to beyond. Correct? Okay. So this is like a legislative timeline. Now, what? Okay, is somebody doing
Uh,
something?
yes, ma'am. Ma'am, just wanted to ask, is it getting recorded or not?
Yes, sir. We are recording.
Okay. Thank you. Thank you.
So if it's fine, if you have any other thing, then also like it will be provided to you.
Sure. Thank you.
So actually, this act, Patents Act, it derives its source from our previous British laws, like British legislations. So basically, it is based on the patents laws which were applicable or introduced in the UK, Britain, in the earlier eras. Act Six, India's so Act it was Act Six at that point of time. It was called India's first patent law, and it was modeled on British legislation. Now, then we come down to 1911, where we had a consolidated law of Indian Patents and Designs Act, wherein patents and designs were brought together under one law. So this is not much more relevance. Just you should know that how it has evolved. Then in 1970, the act which we actually read now, Patents Act 1970, that time it was passed in India, replacing the 1911th Act for patents. Specifically for patents, design was removed out of it. Now, coming on to 1972, the Act had already come into force, but uh, it had been introduced in 1970, but it was not passed by that time. It came into force in 1972 along with the original patent rules. So we have seen that with other laws also, that it will be introduced in the parliament and it takes some time for approval, and that time it is just introduced in the legislature, and for it to come effectively it takes some time, usually for any law. So that 1972 was the year when it came into force. And coming down to 1999 to 2005, this was a major an area or like a phase where we had three major amendments bringing India into TRIPS compliance, because India also signed the TRIPS agreement. Okay, so there were three amendments which we will discuss in the coming classes, because earlier we were granting, process patents. Now we started granting product patents also after 2005, and in between there was also like a closure where the applications could be submitted but they were not being processed. So all this will be discussed in detail later. Okay. So any doubts till now from this evolution? Can I proceed?
Yes, ma'am.
Okay. If I'm going very fast, please you can stop me. Can request that. Okay. So now we see why the law changed. Now, if you're aware, TRIPS agreement, it comes under WIPO. India joined the WTO in 1995 and it agreed to the TRIPS agreement. Now, TRIPS agreement mandated that product patents in every field of technology, including pharmaceuticals also, should be, like granted. Earlier, before this, what we were doing, we were granting process patents in food, pharmaceutical medicines, and everything. Right? This is what it says. Only process patents for food and medicine were given, because we've known that India has been like it has been, diverted towards, or it has a favoritism towards generic drugs, and we also have, like, we are the major producers, manufacturers of generic drugs. So that is why earlier we were not granting patents in pharmaceuticals, product patents, because it would just make access to medicine very costly for the Indian population. Yes, so this thing which I was mentioning, in 1999 we had mailbox applications introduced to hold pharma product patent applications. Like we were just mailing, and then in 2002 patent term was fixed to 20 years for all the patents. New patent rules were introduced 2003, and 2005 everything opened up. Product patents were extended to food, drugs, chemicals, and also section 3D was added. So section 3 is a very important aspect of Indian patent law, because it uh, critically defines what cannot be granted in India. There are quite a lot of provisions in it, covering different like computer science area, traditional knowledge, medicines, and diagnostic area. So like that. If we see in US, we also have certain limitations, but it is quite broader and liberal in granting. Indian patent law is, you can say, aligned or more in sync with how EPO works, because they are also very strict and restrictive in the grant of patents in the area. Okay, so now let's see. Today's Patent Act has 23 chapters, 163 sections, and one schedule. This is the major division which we also see in the Patents Act. Like chapter 2 defines inventions not patentable. This is broadly our section 3. Then applications, how application for chapter 3 goes for how applications have to be filed, what for patents. Then chapter 4, publication and examination. And what happens is, once we file, then the patent application, it is published, and then when we go for, if you want to proceed further, the applicant, then they have to file a request for examination, which we call as the beginning of the prosecution stage in our IPR language. So later in patent, once you become the patent agent, you will be using these terminologies. In chapter 5, we talk about opposition proceedings. Then chapter 8 talks about grant of patents broadly, and chapter 16 is compulsory licenses, which is another aspect of the patents law. Now, see, so this is the act, and we have rules. Now, the act has the sections, okay, and rules. Now, sections are like related to the rules. They work in sync. Now, section defines what exactly is the law, and rules will define what are the forms, fees, timelines, formats, and like the procedural aspect. So we said, see, the act defines what the law requires, and the rule says how to comply with that law, what timelines, what dates, because days and the form, like for example, you have to, what kind of, how many, like what should be the margin area. For example, if I say how the drawings have to be designed in a patent application, that also will be mentioned in the rule. What font size you have to follow, what the margin you should maintain, everything is required. So that is there in the rules and not in the sections. So we have 139 rules across 16 chapters, and we had 2024. There was the most major recent major amendment. I had, I think, included one slide about the recent amendments. We'll move to that. Okay. So this is the hierarchy, officer hierarchy, like in the office of the Indian Patent Office, which controller, we have the highest authorities, the Controller General of Patents, Design and Trademark. Then we have a senior joint controller, deputy controller, and examiner of patents. So examiner of patents and designs are the ones who actually examine our applications. Any questions up to now?
No, ma'am, not from my end.
Okay. Okay. So see, the patent life cycle we just see at a glance. Like the first stage we walk through is like filing. Then after, once, for example, today I have filed my application, which is 17 July, and what happens is, so by autopilot mode or by default, after 18 months, the Indian Patent Office, they have a they release a report, annual publication. So there they will publish your abstract with one drawing, which you mentioned, that which should be published with the abstract in the application, that so and so application for a patent has been filed, describing your invention in the abstract, brief technical details and the technical advantages. That's how the abstract is drafted. Further, that also in publication, if we want our application to proceed, expeditiously, so we have an option of filing a request for early application. That is under a section which we will cover later, like what, uh, how we file. It's a form which we file for early publication. Now after the application is published, then see, even to move on this request for examination, the patent office will not examine the patent application unless we filed a request for examination. That is why it is written request for examination. So this we do in form 18, and we will share a PDF with you, which has all the forms listed and what that forms is specifically for, to be filed at the Indian Patent Office. Once we file request for examination, it also has a fees different for small entity and large entity, natural persons. Now, usually for small entities, the fees is 4,000 rupees. The government fee. Once we file Form 18, we get the patent office gets intimated, okay, that this application should move on for examination. Now they will issue a first examination report, FER. The timeline is not fixed, but yes, they have to act promptly. And then once they issue the FER, they give us a time of 6 months. There'll be a list of objections. There'll be list of objections comprising prior arts. What are prior arts? There'll be like some patent published or which have already been granted. We call it patent literature, and non-patent literature, like some publications, scientific publications or papers, research papers related to the field of the patent application filed, where we have to defend our our invention, that even if a normal person like person state of the art combines the prior arts, will not be able to reach our invention, which we will study in how to set up, or how to defend our response as a comprising of inventive step. And further, like once you submit the response within the timeline of the 6 months, you will have to okay, now there is one more stage in between, which and other jurisdictions it may be known as a second FER, but here we call it hearing, which is done through video conferencing. Now, in hearing, there is another a shortened up form of FER issued, wherein we have to attend the hearing verbally through a video call and with the controller, and we have to defend our invention on the objections raised. We will also show you samples of any FER and also in a hearing notice. It's usually called a hearing notice. A date and a timeline is fixed, like half an hour, 1 hour slot, where we have to argue. It's always on video conferencing right now. Earlier used to be physical also by going to the patent office. So post attending this hearing, you have to submit a draft written submission in respect of what submissions you made during the hearing to the patent office within 15 days of hearing. And also, yes, please remember as patent agents, before the date of hearing, at least before 3-4 days, we have to intimate the patent office that yes, we will be attending the hearing or not. Then only they issue the link for the attendance of the hearing. After the grant or refusal, and then if it is granted, post granted, there may be an opposition, or if no opposition, then also renewal is also there, because we have to pay an annual fees to maintain our patent up to the term of the patent. Okay, now this is like, go through what happens in detail, a little detail. Like, you file the application, you can file a provisional application or a complete specification at the appropriate office, and then we wait for 18 months. That's like the default publication timeline running from the priority date. So what exactly is the priority date? Can somebody tell me? Abhishek, are you aware about the priority date?
Yes, ma'am. Even in the last lecture, ma'am told us
Yes.
about the priority date.
Yes, filing date and priority date. So,
Yeah.
yes. See, for example, I will just clarify. Sometimes it can be same, filing date and priority date. There's a slight, and at times it will be different. Okay, let's just take an example of a normal Indian patent application which we are filing in India only, like which we call an ordinary application. Now, here it is written provisional and complete specification. What happens? What provisional application is that? What happens? Like, if I have an idea and I don't have many, much more details about the invention, but it has been worked upon to some extent. So to secure priority on that idea or my invention or functionality, what I will do is I will file a provisional application today, and within this date of provisional application, I will get a time period of 12 months to file my complete specification. Now, patent office will only start acting when the complete specification is filed. Fine. So, for example, today I filed 17 July my provisional application, and I filed my complete specification on 16 July 2026, after 12 months, within 12 months. So, my priority date will be 17 July 2026, the day when I filed my provisional application, and my filing date will be when I filed my complete specification in 2027. Okay, and priority date we will also relate from when we go for international applications, like as discussed in last class too. Then you can also request for early publication, as I mentioned. The section is 11A, because if we have some, like, things to be met, or we have to launch our product in the market, so we have that provision. Then once the application is published in the official patents of journal, it enters the public domain for the first time. So publication is the step where your invention is disclosed in the public domain for the first time. Any questions here?
None from my end, ma'am.
Okay, no problem. I think Kunal sir has. Okay, Pratik is saying. Okay. See, it may like seem right now, okay, this is too much of this. This is broad. Once we begin the sections, please start reading the sections also, and you will get weekly practice questions. By the end of the first week, we'll be sharing a set of practice questions for you to practice. So I think practicing will also like give you a little jump and help you out to see how questions are drafted and to test yourself too. Okay, now examination to grant stage. We file, as I mentioned, okay, this is mentioned wrong. This was the old timeline. The request for examination now is has to be filed within 31 months. It has been amended. Earlier, it was we were getting 48 months from the date of priority, or the if we don't file request for examination, it will be deemed as withdrawn or be abandoned. That's what the law says. If you have filed the request for examination within the period of 31 months, then the patent office will issue you FER, the first examination report. They will seek your opinions or your arguments on novelty, inventive step, sufficiency. So all these terms are there in the. They are not specifically there, all terms in the Patents Act, but yes, the sections are there, like section 4, 10(4) for sufficiency and disclosure, clarity and conciseness. So these are like headings. Novelty and inventive step has been defined in the definition section, the beginning of Patents Act. Fine. So here in what we do in FER response, we submit our arguments objection wise in response to the FER to the controller. Then there is response in hearing, applicant response in writing, and they may be called or may not be for a hearing before the controller. Like if they are satisfied with the FER, we've had cases where FER was satisfying and we also got the grant before the hearing. So there was no hearing in certain cases. And if the objections are resolved, the controller grants the patent and it is sealed for your term of from 20 years. Now, please note the term of patent does not begin from the date when it was granted. It begins when the application was filed. The file, okay, the priority date or uh, your priority date. I think I'm going very fast. It's already. We can discuss certain things if are there. Now, post grant matters. Now, there is an provision of others to file a um, like opposition to. Now, here it is only there for post grant matters, but yes, before the grant of patent, we also have the option of filing a pre-grant opposition. Section 25 is there. 25(1) talks about pre-grant, and 25(2) talks about post-grant opposition. Please forgive me if I've just mentioned one or two wrong, but yes, 25(1) talks about pre-grant. Now, we have what is this? Like, there are timelines where you have to file for the oppositions. Opposition is basically, for example, like there could be that it is against the law of the nature. There are a lot of heads mentioned, criterias why, where and when you can file an uh, opposition against the filing of that patent. So that is like a kind of a litigation also which goes on. A board is set up. We will study this when we study that section in the act. And then we have renewal fees, which is to be paid annually from third year to keep the patent alive. This fees is provided in detail in the fee schedule. We have working statements. Working statements is there's a form 27. So we have to periodically, inform the patent office that how we are commercially using the invention or how it is being brought out. And revocation, like revocation applications are also filed on certain statutory grounds that another party can file that this patent must be revoked. So there are heads given where why it should be revoked. This is also another section. And okay, let's go on to this. These are some major amendments which happened recently. For example, I said, is it visible or should I just?
Ma'am, it's a little too small.
Sorry.
It is a little small, like.
Yes, yes, I know it is. 90% has. Okay, like broad, we will share in a word copy with you in the notes. Another way. Uh, so, for example, the request for examination, as I mentioned earlier, it was 24 months, 48 months, correct? Now it has been changed to 31 months from the priority of filing date, whatsoever is applicable in the case. If it may be same filing and priority date in certain cases, so we have to file within 31 months. Form 18 is for RFE. Now when you are making notes or doing your own study, or you are reading this like the act, what you can do is against your the section of request for examination, you can in small you can just mention, okay, this is the rule against this. I will tell you when I bring in the act how to write against, like just a study, so that when you're going through you can write the rule also. Okay, for example, if it's section 2, so again section 2 in small you can write R 31, whatever the rule is applicable related to section 2. Because sometimes in MCQs you will be asked, or you will be asked subjective questions where you have to quote the section and the rule also applicable in respect of the question. Okay, and it is always required that we quote both rule, and they can also ask the form, so you can also write this form is applicable for this section. Then we have form 3, 3 form regarding statement of foreign applications. Okay, like section 8 rule 12. So again section 8 you can write that rule form 3 is required here, and rule 12. Now what happens is earlier we had to like for example, oh, okay, are you aware about section 8? Anybody?
Section 8 and 8, no, that is form. No.
Okay, what happens is, like, see, for example, let me see. Okay, I have filed my Indian application, and to file in foreign I have to first take permission also from the government. Now okay, I am going for like to file applications in foreign domains. Now for that I have also filed many. Okay, how do I say? Now what happens is, for my Indian application I will have to earlier what was there, that within every 6 months, let me just give you some timeline. See, today I filed my Indian application 17 July, right? And after 3 months, I also went ahead and filed an application, similar application in US. Right now, this information that I had filed an application in US, I had to provide an update to the patent office, statement regarding patent office in Form 3. This was mandatory requirement, and it had to be furnished within every 6 months of filing of that foreign application. Now this has been removed because it also became like cumbersome for everybody to keep filing, and it was not very easy to keep a track. Although we were doing that, but now it is only to be furnished only when the controller will ask you, or they will issue you a notice that please provide the details regarding foreign applications. Then Form 27, this was about, as we discussed, that we have to disclose what how the invention is being brought out commercially. So now earlier it was supposed to be filed every financial year. Now we have, it can be filed once in every 3 financial years. So there have been changes and amendments in the, like, in the terms, in the years or the timelines. Pre-grant opposition, uh, now this was, I think this is not clear. Representation generally proceeded upon. Okay, I'm actually not very clear about this one. I will let you know about what was this amendment. Okay, actually, I'll tell you this line. Pre-grant opposition, as I mentioned in section 25 1, what was happening is that people were misusing this provision. They were filing pre-grant oppositions in the name of some one person. some random person and delaying the process of grant of a any a big patent application of some pharma or like some vaccine drug or like that. I have also like gone through and I've seen how these patents were filed in in the name of some random person, but it was being done by major opposite authorities or organizations of um, in the market now, and they were being accepted by the patent office. Now what is happening is the controller will only allow those opposition applications to be accepted and proceeded further when they see that a prima facie case exists. So there is like a, a pre-step introduced here, so that there is not much a lot of accumulation of pre-grant oppositions, because this also delays the process. It's like a court thing that we will file first. What will happen is like pre-grant opposition is filed, wherein the applicant who is filing the opposition party, they will submit a memorandum like what are the reasons. It's like a memorandum memo which is we usually use in the legal court procedures. Then the patent applicant will be given some time to file their reply to that opposition, and further both of these were examined and then decided whether this patent should proceed further or it should be dropped out the application. But now this is not the case. How they you know uh, just select the pre-grant oppositions, they will first see what if actually a real prima facie case exists by going through the facts of the matter. Is that clear? Hello. Yes. Okay, I think Abhishek and
Yes.
Pratik in here, sir, is okay. Now. Okay, and sometimes, okay, we have rule 138 you will see when you will read. So this basically defines the extension of timelines for a lot of provisions. Earlier it was limited provisions for extension, but now scope of extensions have been expanded for several prescribed time limits. Divisional application, we will study the types of applications. Section 16, Rule 13, what exactly is earlier the position was not expressly clarified. Rules Now the rules clarify the filing of a voluntary divisional application based on disclosed invention. We also see here impact is not that important. Then certificate of inventorship. Earlier there was no such provision that you are an inventor, but now we have a provision that upon request the controller will issue a certificate of inventorship, because in the patent grant certificate earlier only the applicants or the owner's name was mentioned, patentees. Now penalty adjudication, there was no adjudication procedure. Now there has been a framework for what will be the penalties and how appeals are to be made. Controller powers were very limited digital. Now there have been a lot of changes brought in and giving more powers to them in the management and digital filings. Okay. Yes, in the next class we will first discuss about like the format of the paper, how will it, how the exam is conducted and what kind of a paper it is, what are the qualifying marks, and what actually 60% aggregate really means, and your little roadmap about how this program and mentorship test, okay, and mocks. So, any questions about this slides? If we, okay, I'll just reduce the size. Okay, I think we missed out on this slide. How come? Sorry. Mm, yes, 2 3 slides were missed. I'm very sorry. I don't know. I just jumped. Now, we had discussed that we have 4 patent offices, and each patent office covers certain jurisdiction. Like if you're filing from Haryana, HP, JNK, Punjab, Rajasthan, these states, then your application will be submitted to the patent office based in Delhi. And if from the states coming under Mumbai jurisdiction, then from these states they will go to Mumbai. Chennai will look after the regional states around it, and Kolkata, West Bengal, and all remaining union territories. So this is like a division for the working also of the patent offices for to make it easier. Now, yes, this is what, okay. Types of patent applications. This is important before you start reading also, because these applications will also be covered in the sections of the act. As we discussed, we have first an ordinary application, which is like a fresh standalone application, which does not claim any priority from previous date or anything. Then we have a convention application. Now, convention application is basically there were certain countries who filed the Paris. There was another, an organization or a agreement, Paris Convention. So this was so though this is basically like, for example, Singapore was a part, US was a part, certain countries from Europe were a part of it. So convention application is that for example, if I have filed one application in US a year earlier and now I am filing in India, or I have filed in India, I'm going to file in US after that, I can claim a priority from that application. Is this concept clear? Or convention application, have you like,
Ma'am, I know it, but I don't know about others, so I cannot say a yes for all.
okay, but you were clear, Abhishek. I think you were only there and Prateek is there. All right. No, I think sir, Kunal sir is engaged somewhere. No problem. If he has,
Yes,
we
ma'am.
will discuss.
Yes,
Sure.
yes, I know about this.
Sure, no problem then. Then we have PCT national phase, PCT applications, which has international and national phases. So first, PCT is basically, it is PCT where we file an application not to any country. Like this is what happens is we are filing in WIPO, and there we select a receiving office. So that depends upon your choice, upon your financial budget and the fees, and what actually you are targeting to enter for receiving office. Like for example, if you want India to examine your application, then India, you will select India as receiving office. If you want US to examine your application first under WIPO, then US will be selected as receiving office. So here PCT also has a timeline wherein within a period, this PCT application also, if you're filing, then within a period of 31 months, you have to enter national phases. Now, this period is given to you to decide whether you want to enter different national jurisdictions for, and what jurisdictions you want to enter. Like this is a beneficial kind of a system which has been established, a PCT system. Okay, we can enter other EPO countries, different countries, depending upon what market you are targeting. Okay, Abhishek, you are aware about the PCT procedures? Like, have you worked in any application or something?
No, ma'am, not work, but since the filing department is
Yes.
close, and so I've heard and studied a little bit when I was giving my previous attempts for the patent litigation exam.
Okay,
So
okay.
I'm much aware of it.
Okay, so what happens is, like, for example, recently we filed one PCT application. So here the applicant was a scientist from India. Okay. So what was happening? He was filing through his own pocket. He did not have any sponsorship. Okay. So what we did, we suggested him that what he did, he filed one ordinary application in India. Okay. And within the filing of that ordinary application, we have a time limit of 12 months to file a PCT application.
Yes, ma'am.
Okay. Now, if you don't, then you cannot actually, in certain cases, only we get a provision of like extension of 1 or 2 months, but we have to prove and like meet a lot of procedures for that extension. So within those 12 months, we filed a PCT application because the applicant was looking forward to target markets, like it was a drug uh, based on turmeric. Now they were looking for filing in US and certain countries in EPO and Singapore. So we filed the PCT application. Now here we had budget constraints too because we did not have sponsorship yet from the government or the institution. So what happened? We've selected India as receiving office. Although office does not have that kind of like an image that it is good in examination. Yes, earlier it was not there, but this time we saw that yes, they are good in examining. So India was selected as receiving office. So ordinary application was parallelly moving in India, and PCT application was parallelly moving. Then the Indian office examined the PCT application. They issued like what they do is they will issue you a preliminary search report to give you an idea that okay, where what elements are missing in your, what are the prior arts clashing with your invention and everything. Then another final search report is issued. Now these things have been introduced within this period of 31 months before you enter the national phase, so that you can critically examine that whether you are ready for the national phases and you want to make some changes or amendments to your application. So it's a good provision for the applicants, right? And then also in PCT, please note that if ever any client comes to you in such a situation that they do not have that financial, so for natural persons, WIPO allows 90% reduction in filing fee. Okay, so like from 1 lakh, the fees got reduced to up to like 10 to 20,000 because he was a natural person as an applicant, but not for any other small entity or organizations. Should I explain PCT, or we can, if you want, we can cover later when we study this. Right?
Ma'am, just one thing here, since you mentioned the natural person and the fee structure. So,
Yes.
just curious about it, and I don't know whether it's the right time to ask or not.
No, it's fine. We have time. I mean, I want you guys to have questions, please. Yes.
So, ma'am, regarding this, since we selected receiving office as India, and if we go ahead and file this application, like you mentioned in US, EP, and
Yes.
Singapore,
National.
yeah. So, ma'am, what was the cost that was incurred by the individual? If we just talk about the official, sorry, yeah, official fees.
Okay, see, you will see that WIPO keeps, we have to keep checking WIPO on an average of a very 3 to 4 months. They will keep revising the fee schedule. Okay. Now what happens for this person, when for Indian office it is different. If you select US as receiving office, their fee will be higher. Okay. So for Indian, we had approx. It was calculating up to in dollar. It is always mentioned in like Swiss francs or dollars. So it was coming up to like 1 lakh. Only the filing fee. There
Okay.
are other fees also. Search fee we have to submit. So for India, it was 2,500 rupees only as the search fee to be submitted. And this 1 lakh rupees, since we got the benefit of that 90% reduction given to natural persons, it came down to like approx 10 to 20,000 total. So 25,000 was paid in total around for the PCT application for this natural person, as far as I remember.
Okay. That's,
Because now if I recently I was looking for another, it's a company which they are targeting UAE, US, and certain countries in EPO, but they are a LLP. They are still Udhyam and a micro entity in India, but they will not get this benefit of 90% reduction fees. Like we have fee reductions, different fee in Indian patent, but not in PCT. BIPO will only give to natural persons,
okay. Okay.
right?
So, is
If
it safe to say that if you're filing in multiple countries as a natural person, so like for example, US, EP, and Singapore, so cumulatively, it can be done in about 1 lakh, is it? Is it
uh,
safe to assume?
depends upon what receiving office you select. If you will go to
India.
US, if you want US to examine your application, that patent office under WIPO, then the fees will be higher. But yes, it will reduce to a certain extent. We selected India, so for India, it was the fees was coming to 1 lakh, which got reduced to 20 to 25,000, 10,000 approx, like in that manner. Okay. So that is how like it varies. But yes, the strategy has to be, pre-decided first, rather than just, randomly going and filing. Because
Right.
budget is always very important for small entities, or even for big entities. But yes, natural persons, of course, because they are paying from their own pocket. Okay.
Right.
There are inventors who have they have good inventions, scientists and a lot of research institutions who are looking forward to get their patents, in different countries. And I mean, they face, I have seen it practically. It was one of my clients. And what happens is they face a lot of issues because there are bureaucrats sitting deciding whether this person will get money for the project or not, and the project holds a lot of value, and it takes a lot of time for them to get the grant sponsorship. And uh, it really disturbs the whole process of this patent. On one hand, they're saying please file patent, and on the other hand, uh, they're actually not supporting the government and the bureaucratic system, because there is nobody from the patent or that person who intricately knows that what importance the timelines hold, right?
Right, ma'am. Right.
Okay. And I saw that yes, even the patent examination, like search done by the patent office in India, was good. Maybe the examiner was very good. Earlier, we had this image that India as a receiving office is not good, but they are improving. So, if we have less budget, then we can take India also as a receiving office. Okay.
Okay, ma'am.
Okay, then we have divisional application. Now, divisional application is like, why a divisional application comes into picture. For example, in some patents, you will see that it appears that it is related to two inventions. Now, our patent act always, they will require unity of invention, that it should relate to a single, please remember this term, single inventive concept. From your patent application, it should not appear the claims when you draft that it is going in two different directions. It is relating to two inventive concepts. Now, if any such thing is perceived by the patent office during the examination, then they also issue an instruction for you to file a divisional application. Okay. Now, this is split from a parent application which we had filed, and it will be covering one more invention. This is there under one section. We will study that. So that is called a divisional application. Now, divisional application does not have any further extended term. It will always have a term similar to the parent application which was filed. Like, uh, is there any doubt in divisional application just generally? Um,
No, ma'am.
okay. Now, patent of addition is a different concept. People do get confused between divisional and patent of addition. Patent of addition, basically, for example, I have filed my patent application, okay, and gradually what happens is that I had some experimentations, or the results, clinical results came late, or there was an improvement made in my invention, so I can always file a patent of addition. It will cover an improvement and modification to an already filed invention. We cannot go beyond the subject matter what we have filed, so that will also be considered. Now, this uh, thing which we will file the application, patent of addition, is given. We have to always mention on top patent of addition while filing, and this will be incorporated in your parent application, and this will also have the same term of 20 years as your parent application, no extended term. Now, in divisional application, there is one thing that uh, the divisional application is like a second application which we have filed. For example, if the parent application is at times dropped by you, then and a divisional application may be continued. It will not be affected by the dropping of the parent application, but the term will remain the same. The grant, the protection term of 20 years. And prosecution will also be separately done for parent and divisional application, but not the same in patent of addition. Patent of addition will be merged with the parent application. Like, is it clear? Mm,
Ma'am, could you explain again, like patent of addition, like why in the first place are we like filing it?
This is
Like I
basically like actually it's not a it's like a voluntary provision given to you if you want to add some features which you discovered later. So it's a beneficial provision given to the patentee that if they want to add something to their like any improvement or modification which was not disclosed in the previous parent application, they can file a patent of addition therein, right? Because if we will file an amendment, then they may say that this is going beyond the subject matter originally filed by you.
but ma'am, to my understanding, then it has to be, related to, okay, for example, an HVAC system.
Okay.
Uh, if that is taken into consideration, we did mention a flap as just one of the features of the invention. Like HVAC system, let's take a split AC indoor unit,
Okay. Right.
and the flap, which is the auto air guider, basically. If that was just one of the features of the invention,
Hello. Mm, Abhishek, we're losing your voice in between.
hello, ma'am, I'm audible. I lost
Yes,
my.
we lost your voice in between.
Yes. So sorry, ma'am. So sorry for that.
No problem. It's okay. It's okay. Please don't be sorry. Yes.
So, ma'am, I'll repeat what I was saying. The invention, if the main application was on this cooling coil of a split AC indoor unit, and
Yes.
we in the complete specification we did mention the auto air guider just as a feature.
Okay. Right.
So the patent of addition, can it be elaborating on the auto air guider, or should be more on the cooling coil only?
See, if you have covered your AC as a whole in the patent application, then of course you can include the auto air guider. But only if your invention was only about the like the coil structure, just limited to that, then that might be beyond, completely beyond the scope, because how will you establish that this is a part of the coiling structure? Like if it is there inside or on the the structure, then we can claim, I mean, add as a patent of addition.
Even if that is not the inventive feature of the parent application, right?
Yes, it may not be like one of the main features. That is not the criteria. But if you have made any improvement, or if you have, for example, if we had a spiral or coil structure, I mean, maybe I'm using the wrong term. Please forgive me. And if you read like just added some portions in the spiral structure, or you are not disturbing the core of it, but you have improved the coil structure to increase the airflow, and that could also be one of the features which could be added through patent of addition. May not be a core feature which we called the inventive or novel feature, right? And auto air guider, if you were claiming the whole AC, then you can add as a patent of addition, okay, that this feature was not disclosed in my parent application, but now I have developed it, so this is a part of my invention. Like it's two different things.
Got it, ma'am.
In that. So it depends a lot that how have we drafted the patent application. So it is always like said that the drafting will always define how the journey proceeds, the prosecution journey of the patent up to the grant. The drafting stage is very important. How the claims are drafted um, in that manner, because we all know that claims are like the core features which define the scope of the invention. Right. We will discuss when we draft
Yeah.
do the drafting classes that um, how important claims are. So I
Yes,
hope
ma'am.
you had a little
Okay, ma'am,
like
that was all the questions.
Thank you, Abhishek. I hope you gained a little bit about from today's presentation. And any other questions from any other candidate? Megha has not joined today. She had some engagements. Stop presenting. Oh. So regarding this, you can go through the notes and briefly about this. Another class is also covered in those notes which I shared. And please go through the definition section of the Patents Act, because we have to reread that a lot of times, and even the single words, right? Even what is an inventive concept, what is novelty, and everything. We will also read during our classes, of course, because it's important for understanding and actually handling those questions which are, which require us to think critically, and there'll be questions which say that advise your client, he is in such a such situation. So there we use our understandings and our concepts, and then write that answer. Okay. Interview is usually, I would say, from my own experience also, when I appeared in 2022, it is not very long. It will go on for like either 10 minutes or 20 minutes maximum, sometimes maybe half an hour, but not more than that. They just want you to know and your confidence and how aware you are. The controllers over there, you will usually have two controllers sitting there before you and raising questions there at the patent office. This is uh, how it just goes, right? So, Abhishek, last year was your first attempt at the patent agent exam?
No, ma'am. When I joined the industry, I gave a couple of attempts just to even assess whether it is a good field for me or not. So I have
Okay,
been
okay.
in this field for nearly 4 years now.
Oh, very good. Mhm.
Yeah, and I'm enjoying it every day till date.
Yes, if uh, it's very different. People like if you talk to a layman or a general one of your friends who are not related to it, they will not be even aware about what patents is. But yes,
Right.
it is like it's actually one step above the intellectual level. But yes, it is a very good field, and now people are becoming aware and they are appearing. So that is why they're conducting in every year, and that is why they have raised the standards of the questions.
Yes, ma'am. Like I remember giving my first exam maybe in 2023 or 2024, and
Okay.
I
Hmm.
have literally seen the level rise to,
Okay.
like proper UPSC
Yes.
level sort of, I would say.
Yes. Yes.
Like
Because they
we
had to.
having to brainstorm a lot now.
They cannot just let everybody become patent agents. So, like they
So
were doing
I
this with
was always
trademark agents and
yes,
sorry.
ma'am. Please continue. Sorry, ma'am. Please continue.
No, no, it's okay. They were doing this with trademark agent exam also earlier, that they were just issuing a lot. Now that has also become a very selective one and being conducted every year. Earlier, people used to wait who are not lawyers to appear for trademark agent exam and become trademark agents, because only trademark was known under IPR in India. That trademark patents is gaining importance very well. And even I also ventured in this area. My after my BTech, I had worked in research, and then I realized that okay, there is a lot of scope in this side. Um, it is a good field. I think people should go for this exam.
Yes, ma'am.
That's
It's
why
a
we're pushing Pratik also, who's our IT person too, and we are asking him to just clear it out at any cost
he did
because he's
mention he's
really good.
taking MCA.
Sorry.
I believe, if I'm not mistaken, he's pursuing MCA, right?
Pratik, what are you pursuing? His he is related to some science degree only. Please
MCA.
introduce yourself.
MCA.
Okay, MCA. Yes. So that is actually related to computers only, which is a very upcoming field in IP too.
Yes, ma'am.
So
Like,
Okay, Abhishek, Prateek, I think Kunal sir is not here. Any inputs which or gradually we will keep asking that you want us to, improve, or please let us know. In the group also you can write, and you can get in touch with your personal mentors at any point in time. They are there to help you out. And during these phases, you will, of course, that is why we have assigned our attorneys, senior attorneys. I think Abhishek, you have been assigned Deepshikha ma'am, as I remember.
Yes, yes, ma'am.
Okay. Yes. You may contact her if you want. I can give you her number, and she's also in the group. So you can pick her number from there. And we also met her in the last class.
Yes,
Every
ma'am.
Wednesday, she will be taking our class. And coming Monday, we will share the link. Our managing director, our ma'am, Dr. Shikha Tejswi, she will be taking our class. Okay, for all of you.
Okay.
So let's close up this session. I think everybody's waiting for their dinner. Right. Okay, fine.
Uh, Thank you
Thank
so much.
you. Thank you